Chair of the Public Service Commission, and I'd like to call this meeting of the Board on Electric Generation Siting and the Environment to order. Before moving to the agenda, I'd like to note that this will be the first time that the Siting Board will be considering an application under the amended Article 10 laws and implementing regulations. And I'd like to introduce each member of the board, beginning with the two ad hoc members from the Cassadaga area, and I'd like to thank them for their service to the board in this matter, which has been really diligent, thoughtful, serious, and absolutely worthy of appreciation. So Mr. Gregory Gain, Greg, and Mr. Carl Kelling. Continuing, representing the permanent members of the Siting Board, we have Lou Alexander, alternative Basil Sagos of the Department of Environmental Conservation. We have Dr. Elizabeth Lewis Michael, Betsy, alternative Dr. Howard Zucker, Department of Health. We have Vincent Ravashir, Vince, alternative Howard Zemsky, Empire State Development Corporation. And we have John Williams, alternative Richard Kaufman, New York State Energy Research and Development Authority. So, Secretary Burgess, are there any changes to the agenda?
Good morning. There are no changes to this morning's agenda.
Well, then let's proceed. So, case 14F0490, which is the application of Cassadaga Wind LLC for a certificate of environmental compatibility and public need pursuant to Article 10 to construct a wind energy project, presented by Dakin Lecaques, Administrative Law Judge, Department of Public Service, and Nicholas Garlick, Administrative Law Judge, Department of Environmental Conservation. Paul Agresta, General Counsel, Department of Public Service, and Michael Warden, Director, Office of Electric, Gas, and Water, Department of Public Service, are available for questions. Judge Lecaques, would you please begin?
Thank you very much. Good morning, Chairman Rhodes and members of the Siting Board. I am Administrative Law Judge Dakin Lecaques of the Department of Public Service, and beside me is Nick Garlick of the Department of Environmental Conservation. I would also like to recognize the input of DPS Administrative Law Judge Kevin Casuto to this matter. Judge Casuto served as presiding examiner until his retirement in April 2017. As the Chairman noted, today marks the first time that the Siting Board meets under the reformed Article 10 signed into law by Governor Andrew Cuomo in 2011 as part of the Power New York Act. For your consideration this morning, you have before you a draft order that would grant EverPower subsidiary Cassadaga Wind LLC a conditional certificate of environmental compatibility and public need to build a wind generating facility in portions of 4 towns located in Chautauqua County, New York. EverPower commenced this case in November 2014 when it first indicated its interest in constructing a wind energy project in portions of the towns of Charlotte, Cherry Creek, Arkwright, and Stockton through its filing of a public involvement plan. After meeting with both local and state agency stakeholders, including holding public forums on its project plans, the company submitted a preliminary scoping statement in September 2015 detailing the studies that should be included in its formal application. Cassadaga Wind filed that application in May 2016, and after receiving public comment and providing a number of supplements and amendments, the application was deemed compliant with the Article 10 regulations in November 2016. During these proceedings, the company has remained in contact with the stakeholders to try and make its application as comprehensive and informative as possible. Additionally, public comment was allowed from the earliest stages and has continued to be gathered throughout all phases of this matter. In January 2017, Judge Garlick and I held a public statement hearing and procedural conference in Sinclairville, New York, a village located within the project area. All of the proceedings were held in the local community as required by Article 10, and several community residents took the opportunity to attend the proceedings and to participate. Community attendance and participation included sitting with us through 7 days of evidentiary hearings in July 2017 at the same Sinclair venue, a hall adjacent to the village's fire department, as did the ad hoc members of the Siting Board who are here with us today. The record compiled in this case, both through the evidentiary hearings and the public comments, is extensive. The hearing transcript is over 2,350 pages long, with numerous exhibits, many of which consist of multiple parts. In addition to the public hearing transcript, more than 165 public comments were received and reviewed. After considering the record, Judge Garlick and I developed recommendations for a reasonable outcome of all the issues raised. Secretary Burgess released our recommended decision in November of 2017 with a schedule for the parties to file exceptions to those recommendations. At that time, Secretary Burgess also opened a new public comment period specifically directed to the recommendations that were made. The draft order that you have been provided with is a refinement of our recommendations, adopting some while modifying others. What changes were made were based on the parties' exceptions and the input of DPS and DEC advisory staff. The draft order, if you vote in favor of adopting it, would grant a conditional certificate to Cassadaga Wind to build a wind farm consisting of up to 48 turbines and associated facilities, including access roads, collection lines, and a generator lead line. The project would interconnect with National Grid transmission facilities. Cassadaga Wind anticipates that its project will be capable of producing up to 126 megawatts of renewable wind-generated electricity, helping New York attain its renewable goals as established by Governor Cuomo and the Public Service Commission in several important proceedings aimed at reducing the state and region's reliance on electricity produced through the burning of fossil fuels. These matters include the Renewable Portfolio Standards, the Clean Energy Standard, and the Reforming the Energy Vision matters before the Public Service Commission. I would like to quickly highlight some of the elements of the draft order that address the points in this matter that provoked the most discussion, as well as the most relevant differences between the draft order and our recommended decision. In the RD, we adopted DEC's recommendation on an operational regimen designed to try and eliminate bat fatalities. After considering the uncertainties of relying on operational curtailment alone, when weighed against the potential loss of renewable energy, and with DEC's indication in its exceptions that it was willing to work with Cassadaga Wind to develop a proactive mitigation program that may result in a net gain to bat populations, the draft order allows for less curtailed operations, but requires the development and approval by DPS and DEC of a detailed approach that seeks to preserve and protect bat communities and to encourage population growth and viability. Protections for the local residents for the potential from unwanted noise have also been strengthened through the adoption of a daytime standard, as well as imposing both a long-term and short-time standard on noise emissions. The draft order also clarifies that low frequency and infrasound should be considered at both the inside and outside of a residence to minimize annoyance through both through physiological perceptions, but also from structural vibrations. For the Boutwell Hills State Forest, Cassadaga Wind will be allowed to use steel monopole structures, eliminating the need for stabilizing guying wires, but not required to place the lines underground. This modification from the RD recognizes the presence of an existing overhead line along the road running through the forest, so that a steel monopole addresses the concerns about the use of guy wires, but does not result in a change of character of the forest or road along which the collection lines will run. Finally, the draft order addresses decommissioning along lines similar to our recommendations, adding some clarification. The certificate holder will be responsible for obtaining a letter or letters of credit in the amount of its initial estimate, which will serve as a floor for the duration of the project's existence while requiring updates to that decommissioning estimate. To offer further assurance that there is no deficiency in decommissioning funds, any salvage and resale value will serve as a contingency should additional funds be required. Chairman Rhodes, members of the Siting Board, thank you for your consideration of this draft order. Judge Garlick and your advisory staff are available for questions at this time.
Thank you very much, Judge LeCakes, and thank you again to all the staff and parties who contributed to this. I will now open the floor for comments and questions. and I will begin with my own comments and then turn it over to my fellow members of the board. My own comments are brief. This is an important project, and we've heard some of the numbers that characterize it. 48 turbines, 126 megawatts, 4 towns affected, 3 of them hosting the turbines, the first of its kind. The state needs and state policy calls for renewable energy that is appropriately sited. This means something. This means energy projects that are designed to succeed as energy projects for the benefit of all New Yorkers, but also critically projects that protect and accommodate the concerns of local communities and of the New Yorkers who live in them. This is the first case under Article 10. It's a process designed to balance many considerations, and I appreciate the seriousness of purpose that all have brought to this matter. The submissions, the comments, and other inputs have provided the basis for good and thoughtful discussions and for a good and balanced decision which we can take today. I'll add 2 specific observations. I find it noteworthy and positive that the project is consistent with all local laws and ordinances in the spirit of the appropriately cited point that I made earlier. I also welcome the points where this order provides clear guidance for future projects. These are complicated matters, and as much as possible, when we provide specific, objective, and predictable standards, we are providing a great and important help to communities and to developers as they consider future projects. I'm going to vote in favor, again, with thanks and appreciation for all the work that went into this order. So I'd like now to ask if there are any questions or comments from my fellow board members. And I am going to proceed from my right to my left. So, Lou Alexander, comments or questions?
Thank you, Chairman Rhodes. I would like to concur certainly with the remarks that you have presented relative to this project, its importance and significance. Also to commend all relative to the extensive work and input that was received and consideration given, both through the public outreach process, the recommended decision, and this order that is before us today. Thank you.
And sorry, just as a matter of procedure, this is a round of questions and comments, not yet a voting moment. So some of us are seasoned and some of us are doing the service for the first time, so I thought I'd clarify that. So, Mr. Gain.
I only have a short comment.
Do you want to turn your mic on?
Yeah, the state's done a good job.
Thank you. Mr. Kelling. Dr. Lewis Michael.
I have no comments or questions.
Mr. Ravashir.
I do have just one question I'd like a little clarification on. Is the public interest standard. Could you describe a little bit your approach to that public interest standard issue?
The approach that I took in the recommended decision as well as in the draft order is that it was looked at as one of the characteristics that the siting board should consider. It's not a standard that would be considered above any of the other standards It was taken right out of the public service law and the way that it's constructed, where it requires that the board consider certain environmental impacts, the public interest standard, and then some health impacts and so on, the environmental justice concerns. So I considered it as equal to each of those standards. But the one thing that I did do is I looked at it as kind of an all-encompassing question. And when you met the environmental standards, when you met the health standards, when you considered that there were no environmental justice concerns, and you considered the goals and policy objectives of the state for renewable energy, and put those all together, that's when I determined that the project was in the public interest. One other thing that I did consider, however, was the impact to the community, whether it affected the character of the community, even though it's not an environmental justice community. I also considered whether it was consistent with the local laws and was seeking any extraordinary waivers or anything like that. So I put all those together and determined my recommendation that this should be considered in the public interest.
Thank you. I have nothing further.
Mr. Williams.
Just reiterating maybe other comments that I commend all those who were engaged in the process as the first of the process, first of potentially many. It is good to see the states advancing with a proceeding that can lead to a very robust examination of the many different types of issues that need consideration, and see in the proposed order that any mitigation steps that were needed to be taken all appeared to be very reasonable and allow the state to continue to advance on its myriad policy outcomes that it is looking for in terms of development of renewable energy. So with that, I just am glad to see that we have a very robust process that has gained its feet underneath it. Very much commend those who all of those who have been engaged in the proceeding, and appreciate that we have such a well-reasoned process before us for consideration.
Thank you. Are there any further second round of comments or questions? Seeing none, I will then proceed to call for a vote. I'll share my own vote, and then we'll work our way down the same row. My vote is in favor of the recommendation to approve the application of Cassadaga Wind LLC for a certificate of environmental compatibility and public need with conditions as described. Mr. Alexander, how do you vote? Mr. Gain, how do you vote?
I'm in favor.
Mr. Kelling, how do you vote?
I'm in favor.
Dr. Lewis Michael, how do you vote?
Aye, in favor.
Mr. Ravashir, how do you vote?
Aye, in favor.
Mr. Williams, how do you vote?
Aye, in favor.
Thank you all. The matter is approved and the recommendation is adopted. Is there anything further to come before us today, Secretary Burgess?
There's nothing further to come before the board today.
So with that, I'll move very quickly to adjourning, but I do want to end on, once again, a note of thanks and commendation for the high quality of work that has gone into this. We are adjourned.